Record. Hi, everyone. I'm Bob Linares with the law firm of Redmond, Linares and Beecham, and today we're going to be talking about power of attorney documents. Why are they important, and what do they do for you? So there's two basic types of powers of attorney documents that we're going to be covering. One is what's called a general durable power of attorney, and the other one is a healthcare power of attorney. Both of them are important to have in place. And to illustrate that point, I want to start off with a little story. Not long ago, a client came in to see me. The client's mother, he had been diagnosed with dementia, and the daughter, who was my client, had come in to see me. Um, I'd done some previous work for her, and she said that her mother had been diagnosed with dementia. She needed some help in making decisions, both with dealing with their finances and with their health care issues, and she wanted to become the power of attorney for her mother. And this little story really highlights a problem. Mom already had the diagnosis of dementia at that point, and she really was in a position where she was no longer capable of signing documents and naming her daughter as her power of attorney. So, at that point in time, it really becomes a problem for me as the attorney to help the person, because in reality, the mother would be my client. Okay, I would need to make sure and be satisfied that she had the mental capacity to sign those documents and that she wanted her daughter to be the power of attorney. So this story illustrates the importance of having a power of attorney document, whether it be general power of attorney for finances or healthcare, in place before you reach the point where you are mentally incapacitated, whether that be through some type of a diagnosis of dementia or whether that be that you're involved in an accident of some sorts. The importance of having these documents in place now is really a fundamental thing to keep in mind. So the first question that we ask is, what is a power of attorney? Okay, well, power of attorney document is a document that in which you are giving the ability to make decisions on your behalf to someone. The person who signs the document and is called the principal. And you'll see that in the power of attorney documents, that the person who signs the document and who gives the authority to act to someone is called the principal. The person who's acting on behalf of the principal, that person in the general power of attorney document is called the attorney in fact. That's just the name they use. And then in the healthcare document, that person who's acting on behalf of the principal is called the healthcare agent. So when you see those terms in the documents, that's what they mean. This graphic here highlights the importance of having a power of attorney document, and the fact that many people don't have them. As you see, only 6.2% of the population has what's called an advanced healthcare directive or a power of attorney document, and only 32% had some sort of a will or a trust. And without the documents, such as a power of attorney, you're going to be faced with a difficult decision of having to go to court perhaps to get a guardianship. So it's important to not fall into that to fall into the category of, it's important to be in the category of people who do have advanced healthcare directives or powers of attorney. When a client comes in, as I said, such as the situation that I described in the story, if the mother would come in to talk to me, or if I had to go to visit the mother at her home or wherever she was at, then I would need to determine whether or not the person has the mental competency or capacity to sign the document. And that that's a standard that really is not that difficult to meet. So as long as the person knows who they are, knows their name, knows who their family members are, knows generally what their assets are, not down to the penny necessarily, but just generally knows what they have. They understand what they're signing. They understand when I tell them this is a power of attorney document, that they're able to communicate with me that their intention is that they want to name their daughter or whoever it is that they would like to name. Uh, they have to be able to pass that basic standard or test. If they can do that, then they can sign the power of attorney document and I can help them. If not, then we may have to go through the guardianship process through the probate court. So once you have a power of attorney document, it's important that you keep it up to date, okay? And by keeping it up to date, what I mean is that there are things that of course happen in life, such as your healthcare agent or your attorney in fact may have died. You may need to remove them for some other reasons, such as they're no longer capable of handling the position, or you've lost confidence or you've lost touch with them. Uh, if any of those reasons occur, you need to update the document. Also, people will have older power of attorney documents, some of them, 15, 20 years old. And at the time that they were done, um, you know, maybe, they were a little vague with regards to the powers that they gave to the agent, or it's just, they're just not very well written documents. And in such case, it may be wise to just replace that document and update it with something that's more current and is in compliance with today's laws. Also, if you've moved to another state or from another state, you may need a new power of attorney document because each state has different laws. And so it's worth going to an attorney to look at that and see if it needs to be updated or replaced. Second thing to know, who do I select to make choices on my behalf and when do I want them to begin acting? Okay, so who do you select? Well, you need to have a person in there, obviously, that you have a lot of trust in. That's really the key. Because this document is a very powerful document. It gives the person who you name the ability to handle your finances, the ability to make healthcare decisions for you. You want to have a person that you completely trust in there and that you know is responsible and will be there and do the job when it needs to be done. Typically, you'll name one person. If you're married, it probably is going to be your spouse, and then you'll have a backup, or at least one backup. You may have two. I usually recommend two if you have two people that you can name as backups, each in an order. Okay. You do not need to have the same person as the general durable power of attorney for your finances as you do for the healthcare, but you can. And sometimes there are different reasons that you want different people serving in each of those power of attorney capacities, such as you have one person who's good at finances in the family and you have another person in the family who is better off making the healthcare decisions. So you might choose to have different people in those positions. You can also have multiple agents or co-agents. So you could have 2, 3, 4, 5 agents acting at the same time, at least in theory. May not be a good idea, but you could do it. Okay, and sometimes people will want to have, and particularly when this arises, is they may want to have all of their children be power of attorney for them at the same time, each with their theory being, well, I trust all of them. They can each do the job. If one can't do it, the other can step in. It's just going to make it easier. That can work, but There can be problems with that. Obviously, if there's a disagreement between family members about what decisions need to be made, how are those disagreements going to be resolved? Well, usually you're going to have to go through the courts if you can't reach an agreement, which is something that you want to avoid to do. You can also state in the document that, yes, I'm going to name 3 different people to serve as my power of attorney, but they all have to consent. Okay, well, again, you possibly could run into problems there. And so if you do decide to name co-powers of attorney or multiple agents, you want to make sure that you really have a high level of comfort that these individuals will act, together, and that there won't be a problem. Otherwise, I would recommend that if there's any doubt, go with the order where you have one person and then another if that person can't do it. Another choice that you're going to have when you're sitting down with the attorney making out the power of attorney document is whether to have the power of attorney document become effective immediately upon you signing it, or whether it should become effective only at a future date, such as when a doctor decides that you're mentally incapacitated or no longer able to make your own decisions. There's uh, pros and cons and different comfort levels people will have with each of these ideas, and we can talk about that. But know this: whenever the document does become effective, uh, whether you decide to be immediate or at a future date, it's always going to end either when you revoke it, which you can do at any time, or upon your death. Okay, the document ends upon your death. It does not continue after that date. Okay, so it can be either immediately or at a future date, and we can talk about that as to which is better here coming up. Okay, so 2 reasons for having the document become effective immediately upon signing. One, financial reasons. You may be competent when you signed it as the principal. You may be competent, but you decide that, well, I'm getting to the point where I need some help with decisions on occasion, or I need help paying the bills, or I would like for my daughter or my son to talk to the financial advisor. Uh, the power of attorney document, if it's effective immediately, you're allowing that person who you name to step in and help you and pay those bills and talk to that financial advisor, even though you're still competent and you can still do your own banking if you choose to. You're just allowing another person to be able to also help. So that might be a good reason to have it become effective immediately from a financial standpoint. Uh, Also, from a medical standpoint, maybe you would like some help with some healthcare decisions. You'd like your son or your daughter to be able to participate in your care or treatment, to talk to the doctor about your condition or about prescriptions. And so that's a good reason to have it effective immediately. The other thing is that if it's effective upon you becoming incapacitated, that usually requires a doctor to certify that you are incapacitated. Well, that may require some time to get that certification. So the effective immediately does allow for a little more flexibility, but again, you can choose to have it effective upon your incapacity if you feel more comfortable with that. The third thing to know: what powers do I want my healthcare agent and attorney, in fact, to have? Well, you want to make sure that the document has a broad range, because remember, the person who you're giving those powers to is a trusted person, and you feel confident that they will make decisions on your behalf. You don't know what decisions they're going to need to make on your behalf as you sit there signing it. So you want the document to be as, broad as possible to encounter and to cover all of those situations that might arise. So in the document, we generally will state a whole host of different powers that we'll give to the healthcare agent or to the attorney in fact, so that it covers all the circumstances. Okay, because if there's a circumstance that arises and the power of attorney document doesn't allow for that because it's not in there, well, then the person's not going to be able to carry out that duty that may need to be done. So we want to make sure that it does have broad powers. Is that a concern for fraud or abuse? Well, yes, in the wrong hands it is, but it is a powerful document. You are giving it to somebody you trust, and as long as you're aware that there are these potential issues, and you feel comfortable with that person, then I would recommend as broad a range of powers as possible. In the healthcare power of attorney, one of the critical decisions that you will make is whether or not to have that healthcare agent make decisions on whether or not to allow for life support or other end of life type of decisions after consulting with a doctor, of course. So there may be a situation where the doctor talks to you about whether or not, as the agent, talks to you about whether or not, you know, life support such as feeding tubes, ventilators, uh, should be used. And if the healthcare agent has talked to the principal about in advance about what their wishes are, then they can communicate those wishes, knowing what that person would want. Okay, and that does allow for some flexibility. The other alternative is to have an advanced healthcare directive document, which is a separate document in which you check off boxes about whether or not you do or you don't want certain life support to be administered to you, such as I do or I don't want a ventilator, I do or I don't want a feeding tube to be inserted, I do or I don't want CPR. Okay. Once you check those boxes off, there is less flexibility. Okay, it's the world is oftentimes shades of gray from a medical standpoint, and the advanced healthcare directive document is can be interpreted sort of in a black and white manner, and so the power of attorney document, if you give that decision-making authority to your power of attorney, to your healthcare agent, does provide a little more flexibility. One thing that's very important, though, is that in all circumstances, if you are in some way able to voice your own decisions, okay, you're going to be the one that the doctor asks that question to, not your agent. You'll ask that he or she, the doctor, will ask you that question. Do you want these extraordinary measures taken? What is your thinking on this? If you're able to communicate with the doctor on those issues, regardless of whether you have a power of attorney document, the doctor is always going to ask you, okay? The agent will play a role if you can't communicate those decisions, okay? Fourth thing to know, how does a power of attorney document work in real life? Well, from the standpoint of signing the document, it's really pretty straightforward. The principal and not the agent is the one that signs the document, okay? You would sign the document in the presence of a notary typically, and that would make the document authentic. There's no requirement in Missouri that witnesses be present to watch the principal sign the document, although in some cases, because some states do require witnesses, you may feel comfortable, and the attorney may, because you might say, well, sometimes we go down to Florida and they require witnesses in that state. Okay, let's have some witnesses signed so that that document is portable and you could bring it down to Florida, right? So that in certain circumstances, we may, have witnesses signed, but usually, as long as it's signed in the presence of a notary, it's a valid document. You always want to keep the power of attorney document in a place that can be easily accessed by your healthcare agent or your attorney, in fact, or you want to give them a copy of the actual document. And in most cases, in the documents that I prepare, the power of attorney document, whether it's a copy or an original, is valid. And it states that right in the power of attorney document. So if you give your agent a copy of the document and he or she has that, they can act on your behalf whenever they need to in an emergency. Otherwise, you would need to have it in a place where they can get to it quickly. So that's why you don't want to have it in a safe deposit box, because the bank might be closed on a weekend or in the evening, and you want to have access to it. If you go to the hospital, you want to bring it with you. If you want to, if you have a regular physician that you see, you'll want to give them a copy so that they have it on hand. Likewise, from the financial standpoint, you want to give a copy to your banker, to your financial advisor, especially if it's a situation where you would like the attorney, in fact, to act on your behalf immediately. So the banker, the financial advisor, will know that they can speak to and deal directly with the person who you name as the attorney. In fact, you'll obviously want to give them a copy of the document so that they have that on file and are aware of that. So it's important that whenever you're acting as the attorney, in fact, for the principal, that if you have to sign documents, that you sign them correctly. And by that, I mean that you sign your name as the agent, John Doe, as power of attorney or as attorney in fact for whomever it is that you're signing on behalf of. You don't want to sign just your name, because if you do that, it's possible that that may be construed as you personally agreeing to the contract that you signed, and you're not agreeing, uh, to be responsible personally. Usually, what you're agreeing to is that you're agreeing to that you're signing on behalf of the principal. So typically, when you sign agreements in your capacity as an attorney, in fact, you're not personally liable, because you're just signing as their agent. The principal remains the responsible party from a financial standpoint, but it is important that you sign the document correctly, signing as the power of attorney and not just in your personal name. Fifth thing to know: can an attorney create a power of attorney document for a principal when the principal is no longer mentally competent? Well, we've touched on this. Once you're mentally incompetent, and then we have to go through a guardianship process, which is a probate court process. So if the attorney decides that, the person who's the principal, he is met with, just is not capable of signing the document, then usually what you're going to have to do is go through the guardianship process, which requires a probate petition be filed for guardianship, and a hearing be held, and a doctor to testify and declare that the person is mentally incompetent, incapable of making their own decisions and caring for themselves, in which case the court then will appoint a guardian, usually the person who applies, who's the family member that applies. But that's a much more drawn out, expensive process that can be easily avoided with a power of attorney document in place. So what are the key takeaways? Well, two types of power of attorney documents: healthcare, financial. You got some key decisions that you need to make. When do you start the power of attorney? Is it effective immediately, or is it effective upon the date that I become incompetent? Well, we talked about the pros and cons of that. Usually it's best to have it effective immediately. That's my view. What powers do I want to include? Well, you want to include as many powers as possible, because this is, again, a person that you trust, and you want them to be able to take care of you and do whatever you could have done. In other words, they're going to be stepping into your shoes, making decisions to care for you. You want to give them every ability that's possible for them to care for you. How does it really work? Well, again, the really practical way that it works is the healthcare agent or the power of attorney is going to bring that document with them, give it to the doctor, give it to the banker, give it to the financial institution to show that they have that authority. Then they're going to sign any documents as the attorney in fact, or as the healthcare agent. They're not going to sign in their personal name. As long as they do that, they're not going to be personally liable for any of the contracts that they sign. When is it too late? Well, it's too late once you no longer have that mental competency to sign. So that's why it's important to have these documents in place, no matter what your age. You have them in place, you can update them periodically, but as long as you have them in place, you've got somebody ready to step in and help you. And you never know when that's going to come into play. So it's good to have it done. Thanks for listening today. We do have a special offer. If you use the promo code here that I've got, Bob2020, I will give you a free healthcare power of attorney. This offer is good through June 20th, and I'm happy to help you with any estate planning, whether it's a healthcare power of attorney, financial power of attorney, revocable trust, wills, other types of planning, estate planning, Medicaid planning. Please give me a call. Happy to talk to you. Thanks, and be safe.